And I want to use this subject as a platform, more or less, or as an occasion to talk about things that I think are relevant to you, who likely will not and have not murdered your spouse and her
hopefully
friend.
Not. Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
Okay, today we're picking up with part 2 in our discussion of O.J. Simpson. I hope that you've caught part 1. It kind of sets the stage for today, but it's not essential. Today we're going to really focus more on the financial piece and asset protection piece as it pertains to estate planning. So we hope you enjoy it. So we're going to shift gears here a little bit, and while our focus is on estate planning, I want to talk a little bit about the rules governing asset protection, because that drove a lot of O.J.'s decisions after 1996. So O.J. recognized that he was vulnerable to collection on judgments from a variety of directions, but especially this $33 million. So he would have sought counsel regarding where he should go for the greatest protection. That probably explains why he was in Florida for a period of time. He bought a house there. The house it wasn't a lavish house, but I think it's pretty nice, especially if you look at interior pictures or some of the aerial photos we have. Hopefully we'll be able to put those up. But he didn't go to Florida and live in what he was living in Rottingham. But on the other hand, remember, his income was cut down dramatically. He still had his pension. That couldn't be collected. That's asset protected.
He had the Actors Guild also paying him like some sort of Social Security, I believe.
Yeah.
So he had like a portion of income from that too, because that and his pension couldn't be collected in Florida.
Yeah.
Or when he was in jail, as we'll soon go on to see.
Yeah, I didn't know that. So he also had what would qualify as wherever his Social Security would have come from, it would have been protected. I didn't realize that he was receiving money for some of those movies. That makes sense.
Yeah, it was the Screen Actors Guild that was paying him. It wasn't like a huge amount. It was like $40,000 something a year, I believe. So a little bit extra. So
really, tax-deferred assets, and Social Security is an example of retirement assets, but subject to the same rules. Whether it's 401k, IRA, et cetera, these things are protected by federal law as to collection efforts, et cetera. So there's two sets of laws that can protect people from creditors, and that includes people who have a judgment against you. And you want to find out what those laws are if you know people are going to be coming after you to take your assets, whether you've been in a bankruptcy, whether bankruptcy wipes out debt, incidentally. Most debts, but not all. But maybe you're wanting to avoid bankruptcy. Maybe it's just a debt related to a dispute, a business dispute you've had. It could be a foreclosure on a house and there was a deficiency that you owe. So people can have lots of reasons for thinking, gee, I need to place my money somewhere where it will be protected from these creditors. Because once they get a judgment, they can take that judgment in what's called a garnishment. Many of you think, a garnishment is like a wage garnishment. It just means that you can collect money from an employer. It's much more than that. A garnishment means that it's somebody who has a judgment in hand, not just a claim for money. And this is an important distinction, is there has to be a judgment where a gavel's gone down and said, yep, you owe this person $100,000. That means that there was a lawsuit. There was a collection lawsuit. It went to trial or it went to judgment. Could have been a default judgment because maybe you, if you're the debtor, didn't bother showing up. And the gavel went down and the judge said, yes, you owe this $100,000. So once that's done, then the person who has gotten that judgment in their favor, the creditor, can immediately take that, and by way of this process of a garnishment, they can take that in to a bank, they can take it to a financial institution, they can take it anywhere where somebody is holding money for you. So when you think about a garnishment, don't think about it simply in the context of, that's how they collect from my wages on a job. The concept is that it gives that person who has a legitimate judgment This is not an example of someone being able to oppress you through some unfair process. This goes through the process. It's very protective, oddly enough, of debtors. They have to go through the process, get their judgment, but once they have the judgment, they can take that to other states too. So they can come after assets that you have in the hands of third parties. That's the general rule to think about if you owe money. So you may ask yourself, well, gee, what if I had creditors coming after me? O.J. Simpson doubtlessly had the best advice regarding this. And incidentally, we don't know that he took his lawyer's advice. And often on topics like this, clients do not because they want to go out and buy something else. But assuming that he had good lawyers and was getting the right advice, then O.J. was likely told, look, the best place for asset protection is probably in the state of Florida.
Mm-hmm. Everything you build for you and your family deserves protecting. All of those important assets you have worked so hard to acquire and enjoy, you want to make sure they're handled with care. At Tucker Allen, our attorneys will customize an estate plan that will work for you and your family's goals and needs. Tucker Allen, estate planning, probate, and trust administration. Visit tuckerallen.com.
When I talk about asset protection, I'm talking about things that have immunity to what I've just described. So when I talk about the ability to go and find anybody that's holding assets of yours, any institution, et cetera, banks, then I'm talking now about there are some exceptions where it is kind of, I won't say bulletproof, but there are some types of assets where the law has said, either state, federal, or both, have said that these things are so important that we know you can screw up and you can have legitimate creditors, but we don't think creditors should be able to take them. What would you expect to find on that list? Well, we would expect to find a pension. Mm-hmm. As a matter of fact, all tax-deferred assets, because they're really retirement assets. When I say that, I'm talking about IRAs, 401ks. These are things that people count on to live in their retirement. So the fact that the federal government says, look, we don't want to create a Social Security system that's going to provide, essentially cradle to grave coverage and support for our citizens. That's not what we are here. We want people to come up with their own money. Yes, Social Security is designed to help them. Incidentally, that would be immune from those sorts of collection efforts, any payments you had to do through Social Security. But the federal government said also that we don't want people who are relying on their retirement to suddenly become impoverished and become wards of the state. So they'd become wards of the government, in other words. So the way that our federal policy prevents that is it says, look, if something's 401k money, IRA money, certain other assets that have the nature of retirement, then the IRS is saying, or the federal government is saying, look, we'll protect that. Similarly, Florida is saying the same thing, except Florida extends that. You could buy what's called an annuity. And if you just go out and buy an annuity, which that's where you pay a certain amount of money, typically to an insurance company. They get your statistics on when you're likely to die. It doesn't require physical. So you give them gender, age, I think are the basic information according to law that you have to provide. And then they say, okay, for $500,000, we'll guarantee you $10,000 a month for the rest of your life. And it could be an attractive deal. Now, I won't get into the discussions of why that's sometimes less attractive than others. It's a different show. As a matter of fact, it's a different podcast. But the point is, this is something where Florida has said, look, if somebody has an annuity, we're going to treat that as retirement money, so it's fully protected. Florida also says, and a lot of other states say to varying degrees, we're going to recognize a homestead exemption. Now, again, you may say, well, why would government have a policy to protect debtors from legitimate creditors as it pertains to their house? Well, it's not just their house. It has to be their home. And it's called a homestead exemption, and exists in some form in virtually every state. Now, most states, I'll tell you, the amount of protection that Missouri will give, for example, to somebody who's a debtor is they'll say, well, look, fine, we will cover you up to, I haven't looked in a while. I'm not doing this sort of work anymore. It was $8,000 when I last looked, which was 10 years ago. So we'll call it $12,000, $14,000, $15,000. I mean, the point is it's way below what your actual equity, not to mention value of your home, is likely to be. So some say that's not very reassuring, that you know that if you owe somebody money, they can foreclose on your house, but they have to give you $15,000 from the proceeds, if you have a $300,000 house. But homestead is sacred in every state, but it's defined differently in every state. So in some states, it's very gratifying. In other states, not so much. So in Florida, unless the law has changed, it's an unlimited homestead exemption. That means that you can take, kind of like OJ did, you can take $500,000 to Florida, and you can put $500,000 down on a house. And that house is asset protected, meaning that $500,000 that before you used it to buy your homestead in Florida, now you do need to be a resident. It has to be your home in Florida, which it was for a while for OJ. That means that money is no longer available to the Goldmans. And the Goldmans, we should say that in their I'm sure, horrendous collection efforts, and I'm sure Ron Goldman's dad, what was his name?
Fred.
Fred. Let me tell you, Fred was a machine. If somebody kills me, I would like to have Fred as my dad,
me too,
trying to get justice. And let me tell you, Fred was a man on fire.
Yeah, and all he wanted to hear was that OJ did it. That's all he wanted to hear. He didn't care about the money or anything else, but man, he did a whole lot.
Yeah, he said that he would drop the suit for a full confession at one point.
Yep.
And anyway, so Ron Goldman's dad, Fred, he's all over this. I mean, he has lawyers who are using every trick in the book to try to locate assets and to try to collect. So OJ had to find solutions that were reliable, and Florida is notoriously protective of debtors. Certainly, I should say, as far as asset protection of certain categories of assets. In other ways, Florida is friendly to creditors. Mm-hmm. But for OJ's purposes, it's very protective. So I think that explains the purchase of this house that he purchased. You know what street that one was on?
That one was on, I just said the address to Justin.
Well, that's okay. We'll pop it up, and you can see. You can get some pictures. Again, it's not a very lavish house, and I don't know how much OJ liked living in Florida.
I don't think he loved it.
Yeah.
Because he had spent some time as like a kid there, and his family had lived there for a little while. And
I didn't know that.
Yeah, and so I think he didn't really love it. I think it was just bad memories for him.
I think he's an LA guy.
Oh, yeah. I think he got so used to that scene also that he didn't know what to do in Florida, because Miami and LA are starkly different.
And that explains his later move closer to California. I mean, he didn't live in the state of California, but he lived in Nevada, which in the Las Vegas area largely.
Yep.
So that's so close to LA. In any case, so I do think that it's important to get a sense for, why OJ did some of the things he did in terms of estate protection after this judgment that came down, this acquittal. But he anticipated that there would be these civil cases brought. Mm-hmm. And he also, though, knew that his income had gone down significantly. So I think that a lot of the income he tried to earn off the books, we know that he was very protective of his, what shall I say, image, his intellectual property, his brand. His brand obviously had some serious problems after everyone thinks you murdered two people. But still, I think that he used the opportunities that were available to him because of his celebrity to generate money. And that's done through baseball cards. It's done through...
Yeah, even when, and again, we'll talk about, even in prison, he was signing baseball cards and painting things and just auctioning them off for ridiculous amounts of money and all kinds of things. But it was all protected, so... Yeah,
he had the ability to generate income.
Oh, yeah.
And but still, some of that income though would be subject to being claimed beyond certain levels. So your income in virtually any state can, as we've talked already, can be garnished, but there are limits to that. Somebody who has the costs of your housing, your transportation, your basic food. There are formulas in virtually every state that determine the extent to which you have protection, and that ceiling will vary. It can be a percentage of your income. In some states, it can be an absolute amount, and beyond that, you could be garnished. So I think that OJ, obviously I don't have proof of this. I'm pretty confident that he continued to make money off of his signature and things like that, and it's very difficult to trace that. But it could have been a significant amount of income, certainly. And that money is, again, it's protected from collection efforts. There is, how do you garnish? Because you don't know where it's coming from. And I think OJ knew those tricks or soon learned them. But my main point about the Florida move is the asset protection motivation. And I think he continued to focus on those sorts of considerations. And I want to use this subject as a platform, more or less, or as an occasion to talk about things that I think are relevant to you, who likely will not and have not murdered your spouse and her
hopefully
friend,
not.
and et cetera. So we want, whenever you do think about as you age especially, and assuring that your family receives the assets that you want them to have and that you have available to you the assets that you want to have for purposes of income for the balance of your life, it's not an unreasonable thing to think about, how do I protect my assets from creditors? Not that you're a deadbeat. As a matter of fact, I'm assuming that you're going to do all you can to pay creditors, but at the same time, catastrophic things happen. Especially as you get older, like illnesses, you don't have the ability to go out and earn anew. So you operate with great dependency on the assets that you've accumulated already. The days of growth and investment, those days probably peaked in your mid-50s, I'm guessing. You might have been an aggressive worker and investor after age 55. Most people grow very conservative at that point. So that means that it's all the more important that you think about your cash being in places in ways that your income's protected. So I've identified some of those. You should keep those in mind. Is much of your money in places of that nature? Another way that you protect assets in not every state, but many states, it's true in Florida and it's also true in Missouri, is that you can hold assets by tenancy by the entirety. And tenancy by the entirety means that they're in both names. So if a creditor has a claim against you individually or has a claim against your spouse individually, then they can't collect if the asset is held as tenancy by the entirety, because the concept of tenancy by the entirety, unlike joint tenancy with right of survivorship, which means just in joint names and whoever outlives the other owns the whole thing, tenancy by the entirety is much more than that. It only exists as it relates to marriage in certain states. So if you're a doctor in one of these states and you own assets in the name of you and your wife is not a doctor, we'll assume. In any case, she's not participating with you in a particular surgery. And that's the only hole that would exist in tenancy by the entirety, would be if you both were guilty of whatever it was, claim there was. But for certain types of risk, such as those of doctors, marriage by the entirety or tenancy by the entirety is the perfect thing to protect them, because what it does is it says, as long as you own it jointly, then a claim that a person has, they can't get to it. They'd have to have a claim against both of you. And that's very unusual if you're talking about things relating to, your profession or activities that either of the party is engaged in. So I mentioned that it's something to consider. I mentioned the other forms of protected assets, which can come in the form of tax-deferred assets. There's also one other thing I want to mention briefly, because it does tie in with what OJ did here in terms of his planning. OJ created, apparently in like January before he died, he created a revocable trust. Now, I'm wondering why he didn't take protective action of this nature sooner.
Yeah, I was wondering that too, and I wonder if it's just because, but even in jail, he would have had more than enough time to.
But he's been out of jail since
2017.
Yeah, and we didn't talk much about that. We should just say very quickly for those of you who don't know, OJ had left Florida. He moved to Las Vegas. He bought a house in Las Vegas. Mm-hmm. And that gave him, by the way, asset protection up to $650,000. So he was asset protected for this house in Las Vegas because I think was it $1 million house?
Yeah, it was around $1 million.
$1 million, and I'm sure he had a mortgage for say $400,000. So his equity was protected. So it was while OJ was in Las Vegas that he committed this crime.
It was an armed robbery.
It was termed an armed robbery and a kidnapping. That's what he was found guilty of. Look, no one doubts that. Look, this was the get even for the first trial. Mm-hmm. I mean, when you look at the facts of what happened, was OJ incredibly stupid? Yes, he was. And I don't know if he had the gun. I think there was some dispute.
I was reading he didn't have the gun. I also read, though, that the people that he was with were planted by, like, the Las Vegas, police department and kind of, like, got him in that situation to, like, just be able to arrest him and convict him. But that's probably a conspiracy theory. I'm not sure.
Well, I mean, I can believe that it happened short of entrapment. I mean, it is legal. If you think somebody has this propensity to do something and maybe they've been threatening to do it and, OJ's been angry about these guys who've been making all this money without paying him the share that he should get in terms of royalties from these transactions and whatnot. So it might be that the police were aware of this, and so that might not be entrapment for people to kind of facilitate that encounter. But even if it wasn't, you just look at that and think 9 or 10 years in prison, wasn't it?
Yeah, it was. So he got sentenced to 33 years, but he could be paroled after 7, and then he got released. He was put in 2008. He got released in 2017.
So he was 10 years.
Yeah, around 10 years.
Yeah, I thought it was 10. It's 9 or 10 years in prison. And, I mean, again, if you looked at those facts in isolation of this murder trial in L.A., it doesn't seem. But again, no one's going to feel sorry for OJ. So he goes to L.A. and he buys this house. The house, again, is asset protected and it's homestead. So he also it was receiving money. He's receiving money from his NFL pension, again, asset protected, and whatever other of these asset protected accounts that we've talked about that were out there. Then he goes to prison. I'm sure he probably cashed in some of these 401ks and whatnot, things that IRAs, things that he wouldn't want to cash in, but probably had to in order to have some sort of criminal defense, and he certainly needed criminal defense in that case. So I suspect by the time he went into prison, his assets weren't very large. Also, during the stint in prison, he had a foreclosure on his Florida house.
Yes. Yeah. He had filed for bankruptcy in Florida in around 2006, I believe, because that's how the Goldmans got the rights to the book, the If I Did It book. I'm sure everybody knows about that. But then I think it just was like a process of them like foreclosing on the house, and then he got himself in prison, and then it eventually foreclosed pretty early on when he was in prison.
Yeah. And we should talk for a second about the book. That's an example of the power of collection attorneys when you have a judgment. So, he had signed a contract for a book in which it was going to be called If I Did It.
Yeah, it was If I Did It, and then it was Telling My Story, and then the Goldmans got the rights to it, and there was like public outcry when OJ announced it and he decided not to publish it. The Goldmans got the rights to it and they published it and changed the title to If I Did It, The Confessions of a Killer.
Yeah, and to be technically though, I think the publisher but there was such public hue and cry from the public
Yeah.
that the publisher backed away from
Yes.
publication.
Yeah, and they wouldn't.
And then when the family got on board with a different plan that would give the money to the family, then the publisher published with a different title. So collection efforts are something that people have to be concerned about if they think that there could be creditors out there coming after them. So let's go back to talking about the fact that O.J. comes up near death. He has cancer. It was prostate cancer, I think, originally, but they suggested other things. He had heart disease.
Yeah, it went on to be some more stuff, but prostate cancer was the number one cause, what I was reading.
Yeah. And he didn't look like he was in good health anyway.
No, not at all.
So he creates this revocable living trust in January, and he dies in April.
Yes.
So I asked myself, why would he not have done a more thorough plan? I'm thinking that there were not a lot of assets left that were still protected.
Yeah.
I'm thinking that he probably had to invade a number of those. Typically, I should mention, too, that depending on the state, and I don't know the answer of this for the state of Nevada, but I do know that typically you do have protections to a certain amount regarding any sort of life insurance you have, if it has cash value. If it doesn't have cash value, then it's fully protected. But if it has cash value, then different states give different levels of protection. Some states give very little protection, actually. But in O.J.'s case, what I think happened is that he postponed doing this until the end because he didn't think that he would have a lot of assets to deal with.
Yeah.
But ultimately, there would be value related to, as we talked about before, intellectual property. So the funds that can be generated from his estate due to copyright that might be out there and yet to come in terms of movies, productions, et cetera, O.J.'s name's going to be around for a while. It'll live on, if not in fame, in infamy.
Yeah, there's a lot of talks of all kinds of different movies, and I'm sure especially with his death, people are going to feel a lot more comfortable publishing things and producing things.
So, I mean, my suspicion is that O.J., to some extent, lost interest and didn't do this as well as he could.
I agree.
Now, it may be true that if these assets make their way into this trust, or if they're in there already, they may be asset protected. Because at the moment that he died, this revocable trust, remember, if a trust is revocable, meaning you can reach in and grab it and you can dismiss the trust, you can do anything you want. The trust is, in that sense, the law is not going to honor it as having any legal significance, so to speak. And in this case, he lived with this revocable trust. So anything that he had transferred into that trust, I can tell you, was not protected at that time. Now, at the moment that he dies, at that moment in time that he dies, then immediately he would have been the trustee of his trust at that time. He named a successor trustee, meaning somebody who runs it when he's gone. So O.J. dies. He's named a successor trustee, which is the attorney.
Malcolm Laverne.
Is that how you pronounce it? Say it again.
Malcolm Laverne.
Laverne.
Yeah.
You pronounce it as, it doesn't look like Laverne.
No, it doesn't at all, but I was listening to some newscasts and they call him Laverne, so blame
anyway,
them.
so Malcolm Laverne, who was his attorney during his lifetime, Malcolm now is the successor trustee. So anything that was already in there, if what was already in there were everything related to the intellectual property of O.J., then that may very well be protected. And I would even argue probably is. I don't think that would be accessible to the Goldman family hereafter because it's at that point it's no longer a revocable trust and it's a separate entity. If he didn't put that in there, well, let me go back a step. I disapprove of that approach a little bit in O.J.'s case because I think that it took a lot of chances while he was alive. I guess since he hadn't cut these intellectual property deals, there was no way for anybody to collect on them, right? You can't send a garnishment on a theory that, O.J. might decide to form a relationship and collect, some sort of royalties. So it's true that as long as he didn't form those relationships, or those doors may not have been open to him because, again, it wasn't socially acceptable for businesses to do business with him. So it could be that those doors were closed, but they'll someday be open to his successor. In any case, he did take a risk. So for your purposes as viewers, I want you to know that in a case like that, when you keep the trust as revocable, it's dangerous because those assets are fully available unless they're protected in the ways we've already talked about. One of those categories. So in this case, though, he dies. Those were not collected on for reason we just said, because they in this case, it's the nature of intellectual property. So now when those deals come along, the question is, will it be accessible? And I think if he's already put it in the trust, I think the answer is no, because now that door has closed and locked the moment he died. If it has all those terms, and I'll impute to the lawyer that he put in good terms, asset protection terms in the trust, which is easy to do. If he didn't do that, here's the problem. He dies. He now has a will. The will says, a common language for a will, it's called a pour-over will, for reasons you'll understand. So the moment that he died, then the assets that he hadn't transferred in will go into his estate. They wouldn't have had to, but if they weren't in the trust, yeah, they're going to. And once they go into the estate, probate estate, then the question becomes, what happens to him now? Well, let's pull out the deceased will. And a pour-over will says, take whatever assets I have and dump them into my trust. I want all my assets to go to my trust, just as if it's a person. I want all my assets to go to my trust, which he has a name for his trust. So the problem with that approach is that now the assets go into probate. And because this is just treated like a beneficiary, any other type of beneficiary, it means that all those other claimants get to be considered before any distribution to a beneficiary. So if you've ever had a reading of a will of an ancestor who's passed away, then you know that whoever is appointed the personal representative will run ads, will give legitimate creditors a chance to come out of the woodwork and say, wait, before you give any money to any beneficiaries, I have a claim here.
Yeah,
well,
there's going to be a lot.
You can be sure that Fred Goldman's and his lawyers will be there banging on the table saying, don't distribute anything to the beneficiary, which is the trust. Don't give anything to the trust until you've paid our claim. Now, depending on Las Vegas law, there's a priority of claims. It's like in bankruptcy court, you have a priority of claims. Guess who gets in the front of the line? Well, you're probably saying IRS. Actually, before IRS is a funeral home. So burial costs are typically, now Las Vegas or Nevada could be different, but most states, costs of burial get paid first. In other words, they're saying, look, whatever happens, there may be taxes owed, but surely whoever whatever company buries this person, let's pay them. And then whatever's left, we give to taxing authorities. And that's kind of the way it works. First would go to whatever cost of burial there were. Second, and that would include a reasonable casket, not unreasonable. So reasonable expenses associated with burial. And then comes taxing authorities. Typically, the IRS comes before state tax authorities, but I have to think about that because I think in Florida it doesn't. But in any case, so you have the taxing authorities are next in line, and depending on some types of claims, some special categories of claims such as support, alimony, maintenance will come before. As a matter of fact, some states would put like a maintenance claim or an outstanding child support claim would put that ahead of taxing authorities. But I want you to get the idea that before a claimant in a typical lawsuit would be able to collect, all these other claimants have to be paid first. And then if you run out of money at that point, then whoever's next doesn't get any. Now, it may be, hypothetically, that there's nobody in line except the person being paid for the funeral. Let's assume that's, $20,000. And so what if in this case we have whatever value there is in terms of intellectual property that we'll assume was not put into the trust beforehand is now sitting in the estate. So I don't know how that valuation will occur. So we're doing this show early on, so I don't know if the claimants are going to make an argument that there's an asset there that they can claim. I can tell you the IRS has historically had trouble assigning values to this amorphous property, meaning intangible property for which there's no ready market, and there's so much speculation is required to come up with its value. We've talked about this in the show. So there's a possibility that the argument can be made by the personal representative that there is no value here, because how do you prove it? And in that case, whatever residual value there may be will then get moved to the trust. So if it survives a tax that will occur at the level of probate, remember probate you don't want to go to unless you have poor planning or you have no way to avoid it and you're stuck there. Fine, then you deal with it. But if you can prevent probate, if it's you personally, if you can prevent probate, there's every reason to prevent it. I can't think of any not to prevent it. So those are the scenarios that could play out either way here, and it's going to depend very much on what assets were transferred into this trust before, and also on the terms of that trust, which we don't know. Trusts are private, another advantage. So we don't know the terms of that trust. Anyway, we've thrown a lot at you, but we think that O.J.'s case, while it's fascinating in a lot of ways for reasons beyond estate planning, but we also think that some of these challenges he faced in terms of estate planning thereafter raise some issues that people such as yourselves may want to think about as you age for your own perhaps credit or concern reasons, or just good planning. Why take the risk? You may not know you have a creditor. You may not expect to have a creditor. But I find that thinking about asset protection is an important part of estate planning for everybody. So with that, I hope that this has been helpful to you. This has been another episode of Life's Third Act.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.